Kelsen used this word, pure theory of law, to denote the basis norm, order, or rule that forms an underlying basis for a legal system. The theory is based on a need to find a point of origin, all law, on which basic law and the Constitution and gain their legitimacy. One of the prime rules of this category is pacta sunt servanda, declaring that agreements must be carried out in good faith, and upon that rule is founded the second stage within the international legal order. Every treaty in force is binding upon the parties to it and must be them performed by them in good faith. Pacta sunt servanda is related to good faith. The problem with Kelsen's formulation of the basic norm of international law is that it appears to be tautological. It merely repeats that states which obey rules ought to obey those rules. It seems to leave no room for the progressive development of international law by new practices accepted as law, for that involves states behaving differently from the way they have been behaving. Above all, it fails to answer the question as to why custom is binding. Tautologic is a logical argument constructed in such a way, generally by repeating the same concept or assertion using different phrasing or terminology. Another important element in Kelsen's interpretation of law is his extreme monist stance. International law and municipal law are not two separate systems, but one interlocking system. International law and municipal law are not two separate systems, but one interlocking structure, and the international law is supreme. Municipal law finds its ultimate justification in the rules international law by a process of delegation within one universal normative system. Monism. Accordingly, when positivists such as Trippel and Strapp consider the relationship of international law to municipal law, they do so upon the basis of the supremacy of the state and the existence of wide differences between the two functioning orders. Where municipal legislation permits the exercise of international law rules, this is on sufferance, as were, and is an example of the supreme authority of the states within its own domestic jurisdiction, rather than of an influence maintained by international law within the international sphere. Article 27 of the Vienna Convention on the Law of Treaties 1969 down that in so far as treaties are concerned, a party may not invoke the provisions of its internal law as justification for its to carry out an international agreement. While Article 46(1) of the Vienna Convention on the Law of Treaties 1969 provides that a state may not invoke the fact that its consent to be bound by a treaty has been expressed violation of a provision of its internal law regarding competence to conclude treaties as invalidating its consent. This is so unless the violation of its internal law in question was manifest and concerned a rule of fundamental importance. Article 15. In times of war, mobilization, martial law, or a state of emergency, the exercise of fundamental rights and freedoms may be partially or entirely suspended, or measures derogating the guarantees embodied in the Constitution may be taken to the extent required by the of the situation, as long as obligations under international law are not violated. Article 16. The fundamental rights and freedoms in respect to aliens may be restricted by law compatible with international law. Article 42. No language other than Turkish shall be taught as a mother tongue to Turkish citizens at any institution of education. Foreign languages to be taught in institutions of education, and the rules to be followed by schools conducting education in foreign language shall be determined by law. The provisions of international treaties are reserved. Article 90. In the case of a conflict between international agreement duly put into effect concerning fundamental rights and freedoms and the laws due to differences in provisions on the same matter, the provisions of international agreement shall prevail. Article 92. The power to authorize the declaration of a state of war in cases deemed legitimate by international law and except where required by international treaties to which Turkey is a party or by the rules of international courtesy to the Turkish armed forces, to foreign countries, and to follow foreign armed forces to be stationed in Turkey is vested the Grand National Assembly of Turkey. Introduction. Our task in this chapter is to understand the relationship between legal personality and international law. Introduction. Our task in this chapter is to understand the relationship between legal personality and international law. In any legal system, certain entities, whether they be individuals or companies, will be regarded as possessing rights and duties enforceable at law. Law recognizes those entities as legal persons possessing the capacity to have and to maintain certain rights and being subject to perform specific duties. Personality in international law necessitates the consideration of the international interrelationship between rights and duties afforded under the international system and capacity to enforce claims. These include states, international organizations, regional organizations, non-governmental organizations, public companies, private companies, individuals. Despite the increasing range of actors and participants in the international legal system, states remain by far the most important legal person. Despite the rise of globalization and all that this entails, states retain their attraction as the primary focus for the social activity of humankind and thus for international law. Legal personality states. Creation of statehood. Article 1 of the Montevideo Convention on Rights and Duties Rights and Duties of States, 1933 lays down the most widely accepted formulation of the criteria of statehood in international law. Creation of statehood. It notes that the state as an international person should possess the following qualifications. 1. A permanent population. 2. A defined territory. 3. A government. And the last one, 4. The capacity to enter into relations with other states. These were important. These were important ones. Independence. This not be your fuck. The outstanding characteristics of a state is its independence or sovereignty. This was defined in Yes. Yeah. I was expecting someone. I was expecting to not coming of someone. I know. What? Fuck it. Yeah. Where were we? Anyway, independence. The outstanding characteristic of a state is its independence or sovereignty. This was defined in the Draft Declaration on the Rights and Duties of States, prepared in 1949 by the International Law Commission, as the capacity of a state to provide for its own well-being and development, free from the domination of other states, providing it does not impair or violate their legitimate rights. By independence, one is referring to a legal concept, and it is no deviation from independence to be subject to the rules of international law. And we're going to 100 megabytes right now. 100 megabyte indeed, yeah. Any political or economic dependence dependence that may in reality exist does not affect the legal independence of the state, unless that state is formally compelled to submit to the demands of a superior state, in which case dependent status is concerned. The nation of the notion, I think it's notion, no, nation. What the fuck is notion? The notion of independence in international law implies a number of rights and duties. For example, the rights of a state to exercise jurisdiction over its territory and permanent population. The right to engage upon an act of self-defense in certain situations. It implies also the duty not to intervene in the internal affairs of other sovereign states, non-intervention.